Welcome to another episode here on the Lara Poe, episode 2 of 2026. And I have a very interesting episode here for you. In this episode, I'm going to answer the question that was posed to me. And the question is, does a person who is involved in a motor vehicle accident, the driver of a motor vehicle involved in a motor vehicle accident, is that person required to answer questions from the police under caution or to give a caution statement to the police? I'll be back to discuss that shortly. But before I do, my usual disclaimer: this is not legal advice, and nothing that I say in this episode should be taken as a legal advice. For legal advice, please contact an attorney of your choice. So my answer to the question is absolutely not. You do not have to answer questions under caution, or you do not have to give a caution statement to the police if you are involved in a motor vehicle accident, if you're the driver of the vehicle involved in the motor vehicle accident. And in the event that you feel it is necessary for you to answer questions under caution or to give a statement to the police under caution, please seek legal advice first. It has been brought to my attention that there's a practice in the Turks and Caicos Islands where persons who are involved in motor vehicle accident feel that they have been pressured by the police to give a statement under caution in relation to the accident. If this is so, then this is coercion. It is forcing someone, frankly, to self-incriminate or to incriminate themselves, to say things that could be used against them later in court. Every person involved in a motor vehicle accident, or every driver involved in a motor vehicle accident, has the right to remain silent. The right to remain silent is enshrined in the Turks and Caicos Islands Constitution. The right not to incriminate oneself is a fundamental principle of law. There is no general duty to assist the police in their inquiries. The very fact that a person is cautioned at a motor vehicle accident scene, or when they turn up at a police station to give the account of what happened, should put them on notice to shut up. You don't believe me? Then let's look at the caution very briefly. The caution falls under what is known as the judge's rules, and I will touch on that later in the episode. But the first principle is that a caution is a mandatory once there are reasonable grounds for suspicion that a person have committed an offense. So it begs the question, why would a police officer visiting an accident scene and having his first interaction with a motorist or a driver involved in an accident would administer the caution as a first resort and insist that any discussion should take place under caution? What is the officer's suspicion at that time that the person he's interacting with has committed an offense? And now let's get to the caution. The caution falls under the judge's rules. They are of significant historic and academic value in protecting the rights of a suspect or a defendant who is being investigated for committing an offense. They were established in 1912 and updated in 1918. And what the judge's rules established is that a suspect is not obliged to say anything unless that person wishes to do so. But that anything that that person say may be put into writing and given in evidence against them. So first, it warns you that you do not have to say anything. And then it informs you that anything you say may be used against you. So why take the risk? So, what are your obligations if you're involved in a motor vehicle accident? Well, one, while you are not required to speak or you have the right to remain silent, you are legally required to stop at the scene of the accident. A failure to do so may result in charges being brought against you. You are required in law to exchange details with the other driver, such as identification, insurance details, etc. And three, you are required to report the accident to the police and to indicate any injuries or significant property damage to the police when you report the incident. Now, if you do not give a statement, the police have less immediate evidence against you, which will make it difficult to bring a charge against you. You are not required to give an immediate explanation of how the accident took place, or you are not required to admit fault to the other driver or the police. So the police turns up and they ask you for an explanation of how the accident happened. You are not required to give an immediate explanation. You could give that later, advisedly, after you have sought legal advice. And the reason for this is that roadside admissions, even without a caution being administered, may be admissible as evidence against you. So be careful what you say at an accident scene. Now, the case of Rice and Connolly of 1966 confirmed the common law right of a citizen to refuse to answer questions from the police, providing they are not obstructing the police officer in the execution of their duties. But to insist that a motorist involved in a motor vehicular accident only have one option of telling their side of the story, and that is through a caution statement or under caution, is not only coercion in my respective view, but it robs that individual of giving their account as a victim of the motor vehicle accident or even as a witness to the accident. It boxes in that person as a suspect, and that person, if he or she is not careful, may inadvertently incriminate themselves. So, what should the police do when they visit or they are called to a motor vehicle accident scene? That's a question that you may ask. I am not here to advise the police. Let them figure it out. Here's where I'm going to leave this episode for today. If you like anything that I say in this episode, if it has been of any value to you, please share, please like, please leave a comment, please give it a thumbs up. And most of all, I thank you for taking your time out to look at this video. Cheers.